I'm sorry that I can't show my face, Romy, but we welcome you to the club. As you can see, we're various realtors from different brokerages that we're working together collaboratively, and we really appreciate the training that you have for us today. I think we should start. I know, as I said, I believe I see that a lot of people probably on vacation. So, but thank you so much for being with us.
No problem. Okay, let me get started then. Hi, good morning, everybody. My name is Romy Jurado. I'm an attorney here in South Florida. In today's class, I'm going to talk about how realtors can basically protect themselves from potential lawsuits. If I'm able to share my screen, I don't think oh yeah, I am. Okay, perfect. Give me just 1 second.
Yeah, they should start logging in as we speak, but definitely let's get started. Thank you, Romy. Thank you, Gisela.
No problem. All right. So I think everybody can see my screen there.
Yes, thank you.
Wonderful. So our firm is here in Miami, Florida. We practice different areas of law. We do business law, real estate law, immigration, probate, and estate planning. And through that, we work with a lot of realtors, and we've seen where they have potentially faced legal issues. So a common lawsuit that we see involves a scenario where the buyer of a property is suing the seller and then the seller's agent for failing to disclose the property's defects. In some cases, the buyer also sues their own agent for the transaction. The lawsuit alleges not only negligence, but also alleges that the seller and agent conspired to conceal the defects in order to facilitate the sale at a higher price and earn a higher commission. In Florida, sellers don't have to prepare seller's disclosure. However, what I don't want to see is realtors preparing the seller's disclosure for the seller. And I do see that a lot. We deal with a lot of foreigners. They will say they don't understand what they're filling out, that they have nothing to hide, and then they have the agent fill out the disclosure. That is basically asking for a potential lawsuit, because if there's any issue in the property, that is what's going to happen. They're going to come after the agent. So don't fill out seller's disclosure. If the seller doesn't want to fill out a disclosure, then they have to state that, and then that's it. The buyer can decide to buy or not to buy. That's totally their decision. You have to understand also the relationship that you have with your client. It defaults to transaction broker, but I still would want to see something in writing, which basically means that you represent that transaction, not your client specifically. If you are having no brokerage relationship, that also needs to be in writing. If you're representing either the buyer or the seller, basically you are their sole agent, then that one, it's a little more complicated, because now you have to look after the best interest of your client, just like I would, and you have a fiduciary relationship. That means that they can sue you for you doing anything to your benefit that didn't benefit your client. I usually advise agents not to be the sole agent, to be a transaction broker, because that way you can limit your liability as well. Knowledge is power. The most common situation that we see, right, I was telling you guys, is failure to disclose. And in Florida, a lot of times people are fast into buying a property and they're like, just make the offer. I just want to buy it. And then later is when they start seeing construction issues, leaks, noises, or things that were improved without permits. In Florida, you can buy a property that has open permits. There's no restriction against it. The only way that that restriction is going to be in place is if in the contract it says that the seller has to close any and all open permits. If the contract does not say that, then you can simply close with the open permits and it doesn't become a title issue. But of course, they will blame the agent. Now, if you as the agent were representing the seller and you know of something that affects the value of the property, then you have to disclose it, right? You cannot be in cahoots with the seller not to disclose, but only if you know, right? Because otherwise the buyer can potentially hold you liable for failing to disclose. Breach of duty also represents one of the most common lawsuits against real estate agents. You always have to act in the best interest of your client if you're representing them as a sole broker. But even if you're a transaction broker, you have to make sure that if there's something that you think creates a conflict of interest, that you disclose it. You do not want them to sue you for breach of duty. It's very easy to sue. You don't need to prove anything. You just need to allege. And then once a lawsuit has started against the agent, now the broker has to defend, and then you have to hire an attorney and you have to spend money. So the best course of action is to try to avoid potential lawsuits by disclosing, being fair, and making sure that everything is in writing. You want to document everything. We had a situation where they sued one of the agents that we work with because the buyer said that the agent didn't disclose the situation with the roof, and the agent knew. And the agent did disclose, but they never put it in writing. So the buyer said, no, you never told me anything. So now we have to defend the lawsuit, hire expert witnesses, go through a whole thing, and the agent is going to have to pay a lot of money, and the broker is going to have to pay a lot of money for all of this, and their E&O insurance is not going to cover it. So what the agent should have done, put it in writing, send an email. This is to acknowledge the conversation that we had today where I told you about the roof and you decided to proceed with the transaction. Whatever you want, just put it on an email. A lot of situations arise because people are closing subject to financing, and then the time to obtain the financing period expires or will expire, but the buyer doesn't have the approval of the loan. So then what is the buyer to do? If they cancel the contract, they may get their deposit back, but they're losing on that opportunity. And if they don't cancel the contract, they're going to buy it, not subject to finance, which means that if they don't get the mortgage, they're still going to be responsible to buy it. They won't have the money to buy it, so they're going to lose their deposit. What is the buyer to do? I don't know. That's a personal decision of the buyer. But what is the agent to do? Put it in writing. Say, Mr. Buyer, your financial contingency period ends tomorrow. You need to make a decision. Either you proceed with the transaction, not subject to finance, because the seller doesn't want to increase the financial contingency, or you cancel the contract and demand your deposit back. You need to make this decision, because if you don't, we're going to be in breach of contract. As an agent, you shouldn't be making those decisions for your buyer. Let them make those decisions, because later when you make those decisions for them, they're going to come after you. I have seen it. Oh, the realtor never told me the financial contingency was over. Otherwise I would have, terminated the contract and demanded my deposit back. I see it a lot. And then they end up suing the agent too, because it's very easy to sue. So if you have a situation like that where the buyer needs to make a decision, put it on them to make the decision. Don't be subject to a lawsuit for breach of duty. The other thing that I do see a lot also is inspection reports. Basically, my advice is obviously tell your clients to order inspection reports, right? But you're not a general contractor. You cannot explain to them what an inspection report says, whether it's a good deal or not, how much it's going to cost to fix it. That's not your responsibility. And if you start engaging in that, then they're going to hold you responsible. So one thing that I like to do, even when I represent clients as their attorney and they want me to review their inspection report, I'm really clear. And I'm like, I'm not a contractor, so I have no idea what this says, but let me put you together with a general contractor, 2 or 3, that can give you quotes as to what it would cost to fix this. And then you can make a decision whether you want to proceed or not. Make sure that they are the ones making the decision, not you. You will see that in all the inspection reports, they have disclaimers, they have all these things where the inspector basically releases themselves from liability, because it's not insurance. They're not buying property insurance. They're simply getting an inspection report. But it is so important to do an inspection report. Also, it is so important to do a survey. If you're buying finance, if your client is buying finance, then the bank is going to require a survey. But if they're buying cash, the bank's not going to require it because there's no bank. And you will see in the title insurance policies that they will get that it'll be clearly said that nothing is protected which would have been discovered through a survey. So people think that they're being smart by saving $500 or whatever it is to not to do a survey. They're buying cash, so they don't need it. They close the transaction, and then they realize that the fence, instead of being here of their neighbor, is all the way here. So now that area, right, is basically being adverse possessed by the neighbor, and they cannot do anything about it but to do a lawsuit. And when they come and want to use their title policy insurance, and they come to me, they're so happy, well, I bought title policy. Here it is, Romy. Can you make them cover it? I look at it, and it will clearly said that it will not cover anything that would have been discovered by a survey. So then I say, why didn't you do a survey? Oh, my agent didn't tell me I had to do one. I told her that I didn't want to do it, and she said it was fine. So everybody should be doing surveys. Everybody should be doing inspection reports, but you as the agent shouldn't be the one explaining what the survey is, explaining what the inspection report says, because you're not a licensed contractor and you're not a survey company. So be careful with that. Or an attorney. If you are, then by all means explain. But if not, there's no reason why to assume that liability. Breach of contract. When a client claims a real estate agent did not perform under the terms of the contract, then you're going to need to seek legal action. One of the most common reasons for breach of contract is failing to comply with the time frame stated in the contract, right? So again, that inspection period, the closing period, and they will try to come after the agent, sadly, for whatever reason they can find. So you want to make sure that you put everything in writing. I really like when the realtors send this list that say like critical dates and this and the other. But if you're sending that, please make sure it's accurate. Please make sure it's accurate. We had a situation where the buyer said that they didn't get the loan on time, but they didn't think it was an issue because they relied on the email sent by the agent that said the period for financial contingency was a week later. It was a typo, but they said they relied on that. And that's a theory of law. It's called detrimental reliance. So they relied on that. They trusted that. So they didn't care about the loan contingency. And now they're trying to come after the agent. Negligence is another cause of action. This cause of action alleging the failure to exercise due care towards others that a reasonable or prudent person would do under their circumstances. Clients can make claims that a real estate agent should have known something, but they did not and failed to disclose it or take appropriate action. Negligence differs from fraud in that it lacks an element of intent. Often clients seeking legal action will begin by claiming fraud, but if they're unable to prove intent, they will seek reparations for negligence. It's hard to prevent claims of negligence because you might not always know what you should have known. Be sure to obtain insurance coverage for these unfortunate circumstances. So all agents should have E&O or some type of liability insurance, but it's not enough to, yes.
I'm sorry to interrupt you. They're
Sure.
telling me that you're going a little bit fast. A lot of the agents, English is not their primary language. So would you
no
please
worries.
go a little bit slower? Sorry about
No
the interruption.
problems, but I only have 10 more minutes left, but I'll go slower.
Thank you.
No problem. Insurance. It's not enough just to have insurance. You need to make sure that and this applies for any type of insurance that you have for any business, anything. You need to understand the policy, what it covers, what doesn't cover, what are the exclusions. We get a lot of situations where agents come to us because they received a lawsuit and they're telling me that the insurance is not covering them, right? They're not defending them. And the first thing that I do is look at the policy, and then I see all these exclusions. And if there's so many exclusions, then they're not going to cover you because they're going to use one of those exclusions to get out. I recently had one, we represent a lot of medical spas, and they had a liability policy. But one of their exclusions is viruses, right? And I'm like, okay, well, guess what? The people are alleging that they got a virus for getting your services at your med spa. So therefore, the insurance is not going to cover it. And then they tell me, but Romy, the insurance agent never told me. I'm like, you should have analyzed your policy. It would have cost this person $200 more a year to have the policy, $200. And she would have received coverage. And she would have saved the tens and 20 and 30 thousands of dollars that she's investing in basically getting an attorney to defend it. So it's great to have insurance, but it's not enough. You need to understand your policy. You need to understand what it includes and what it excludes. When people ask me, what should I do with insurance? What type of insurance should I get? Get as much as insurance as you can, but it has to be monetarily, it has to make sense, right? So get as much insurance as you can, but understand what it's going to cost you. So if you had this coverage, would it protect you against this? Would it protect you against the other, right? And then you want to understand the policy, and you want to deal directly with the insurance provider. We had an issue recently. A prospect came to me because they bought a property, they got title insurance policy, but they were only dealing with the title company when the title issue arose, right? And the title issue was that the property was not properly platted. So it had a folio number, but it wasn't properly subdivided. So for this past year, she had been dealing with the title company and never dealing with the actual insurance company. And she had done a bunch of things, but nothing for the insurance to cover them. So I want to explain real quickly. Title companies are not the insurance. Title company is an agent. They sell the insurance. If you ever have any title issue, if your clients tell you that they ever have a title issue, have them reach out directly to the insurance company. Who is insurance company? It will say in the title policy. So that way they tell them what is it that they need to do to get coverage from whatever title issue. You don't want the buyer to say that they didn't reach out to the insurance company because you told them only to deal with the title company and they've lost time and now they don't have coverage. You don't want that. Another potential lawsuit that we see is bodily injury. So when you take people to see property, right, they get injured, they can come after the property owner and they can come after you because you're the ones that brought them there. What I like to see is liability releases, right? Before we used to have realtors drive people around and this and that. That's also liability. So what I like to see is when people are visiting other properties that you're taking them, especially pre-construction or houses that need fixing, any potential exposure, you want to make sure that you get a liability release. So that way you're protected and your brokerage is protected because you cannot foresee what's going to happen there. I remember this was 5 years ago. There was a showing and there was a cat in the property. And the agent, of course, didn't know the cat was supposed to be, you know, in a cage or whatever. And the cat wasn't. The cat was loose. And the person that went to see it had real bad allergies to the cat and apparently broke out. So now they allege, they sent a demand letter, it wasn't a lawsuit, that because of the agent, they were injured because the agent didn't tell them about the cat. So now the person had like an allergy reaction and they were injured. I thought it was, you know, not going to go anywhere, but they actually did eventually file a lawsuit and then the agent had to get their insurance involved. So to avoid all of that, have releases, have waivers if you're taking people into property, especially if you're dealing with property that needs fixing, old houses, because there's mold exposure. I would just have, like, whenever you have people sign up with you to be their realtor, I would just have general releases that waive a lot of stuff so that you're further protected. The other one that I see is failing to keep client data secure. Please do not be the agent, and I think a lot of agents know of this now. Do not be giving wiring instructions, right? If the buyer needs wiring instructions, they should get it directly from the title company, from the law firm, and they should verify it with them. You don't want to be the intermediary, give the wrong instructions, and then have their money go God knows where. You also don't want to be the intermediary between the client and the mortgage broker when they, or the bank. When they provide that financial data, it's supposed to be protected. And if you're the one collecting the taxes, collecting this and the other, now you're assuming the responsibility to protect that data. And if you don't, now it's going to be the client's responsibility, sorry, your responsibility. So you want to make sure not to be the intermediary. If they're dealing with a mortgage, have them contact them directly, have them provide the information. If they're getting wiring instructions, same thing. You don't want to assume that extra liability. Misleading clients, well, you know, you don't want to mislead. Every real estate agent strives to make their property stand out from the crowd. It might even be tempting to exaggerate here and there about the features or the condition of the house. However, this kind of deception can end disastrously for agents. If a buyer feels misled about anything, a lawsuit typically follows shortly after. Always be truthful. Allow no room for misrepresentation. A misleading statement might help you close a sale, but it may also lead to legal action and financial loss. It's not worth the risk. So let's not mislead clients. Representing clients in unfamiliar territory. Now, I know you guys are licensed all over Florida, but if you're representing people in other territories, you want to make sure that you're aware of the intricacies of that particular territory. For example, I remember we had a realtor from Orlando that was representing somebody sell property in El Portal. In El Portal, you have to get a pre-occupancy certificate. It's the seller's responsibility to obtain it. It was a whole issue because the seller is like, I am in France. I have no one to do it. I don't want to do it. I did this. I guess they had done like an illegal expansion of one of the rooms. So they didn't want it. The deal went sour. It was a whole mess. Had the agent known from the beginning that in El Portal, you have to get a reoccupancy certificate where the inspector will come and take a look at the property before you're able to sell, maybe the seller would have disclosed this illegal construction and maybe the negotiations would have gone a different way, or maybe they would have legalized it. I don't know. But you want to make sure that you're familiar with whatever territory that you're at. Another one is in Naples, for example, we have a lot of area that is underwater, right? So some of it is upland, some of them is not. And this client ended up buying, it was a piece of land cash, right? And then when they were trying to build, they were not told, they were not informed that even though some of the part is upland, meaning it's not in the swamp, they were still not able to build there how they wanted because the other part that was swampy is protected by the certain law. So you cannot even throw the trees away. You can't even touch it. So basically this person bought a plot of land where they cannot build on. And that's why it was such a good deal. That's why all of these things should the agent been familiar with that area? The agent probably told them, listen, I know you're getting a good deal here, but it's because of this and the other. And maybe that person would have ended up not buying it. At the end, the person ended up filing a lawsuit against the agent for misrepresentation. So you don't want to be in that position. If you're going into unfamiliar territory, either co-broker with somebody that's familiar or become familiar with the territory. I'm not saying don't sell. I'm saying just become familiar. You also don't want to be giving legal advice, right? So I understand, especially those that are from South America, that the clients think that you guys are supposed to fix their life and explain to them everything. You're not, unless you have a license from, the state of Florida to give legal advice in the state of Florida. You want to be careful with that because they will sue you. One, it's called the unauthorized practice of law. Two, they can sue you for giving legal advice and you don't want to be in that position. So what I do, even I do this, right? I'm married to a CPA. I don't like to give tax advice. So I tell them, go speak to a CPA, go speak to this. If they want legal construction advice, go speak to a contractor. They want to know how good is the market in this area, go speak to a realtor, because I don't want to talk about things I'm not licensed to talk about or things that I'm not familiar with. And you want to be extremely careful with those things because that is just assuming liability. Okay, so again, failure to disclose. I see this one a lot because people will buy properties and then they're super unhappy with them and they want to sue everybody who they can to get their money back. Permit or code violations. If the contract doesn't say that the seller has to close any and all open permits or code violations, they don't have to. And if it's not a title issue, they're going to end up buying the property and then the buyer has to deal with it. Water issues, we do see this a lot too. During the inspection, they might not have detected the inspector. So you don't want to be the one to say, no, that doesn't look like a flooding, that just needs some paint. You don't want to be in that position. Structural issues, we do see those a lot, and wiring and electrical issues. That's why I advise people to get the regular inspection, the inspection of the one that's under the house for all of the water system, to get an electrical inspection, to get any and all inspections, because that way they're more informed, right? So what are some things that I recommend? Well, you have to address things with your clients, complaints as the transaction is going on, put everything in writing, understand, this is so basic to the contract, right? So if somebody makes an offer, you present it to your seller says, okay, great, I agree to this, but they make one little change and that little change is not initial. If that little change is not initial, then that's not an actual contract. That's not an effective contract because that change was a counter offer. I have seen sellers and buyers use that to get out of transactions. If a buyer comes to me and sellers most of the time. So sellers cannot get out of contracts. Once they sign that they're going to sell, they're going to sell. But every so often I get a seller come to me and they say, Romy, I changed my mind. I really don't want to sell. I know that I can get more money for this. What can I do? So as the attorney, I review the contract. And I'm like, look, you never initialed that. No, I never did. Okay, then this is not an effective contract. This is an offer which you never accepted. So now you can get out of this. Simple as that. The buyer, they can whine, they can cry. It's not an effective contract because it was never fully executed. And now the realtor is mad because now they're not going to get a commission. Check everything. If there is even the slightest change in the contract, then it's not going to be an effective contract unless that is initial as well. Deadlines, we want to make sure that we lay out when is a financial contingency, when is a due diligence contingency, when is a closing, when should they go and get the title insurance, and not the title insurance, the title commitment. All those things need to be laid out. Work with the title company, or you can work with us to make sure that all those things are followed through so that nothing falls off the track. If you're extending the contract, fine, but make sure you also extend the closing contingency. Otherwise, your buyer's going to have to buy even if they don't get a loan and they're going to lose their deposit. If there's any leases, make sure those leases are assigned. Make sure that their stopple letters are obtained from the tenants, because there's a lot of situations where people end up buying, multifamily housing, and they have like 4 apartments there and they're all happy about it. And then they realize that those people haven't paid rent in 3 months, or the rent that they thought they were paying according to the lease is not really what the tenant's paying. They would have found all this out have they required stopples. So stopple is basically a document that the tenant fills out that says, this is what I pay a rent, this is what they have of my deposit, these are the issues that I have, and then the buyer can decide to buy or not. especially when you're buying commercial property. When we're doing big commercial property like shopping centers and stuff like that, we always get stop loss. So I don't have issues with that. It's when I see the smaller transaction, the duplex, the fourth family housing, like, you know, the smaller ones where people like don't, I guess, pay as much attention. And this is when we see the issues. You know, this is when we see that the tenant hasn't paid rent in 4 months. So you want to make sure that if you're dealing with those transactions, that stop loss are obtained from all the tenants. It's not enough to see what the lease says. You need to get stop loss to know what they really are paying. Watch out for reoccupancy certificates, all those things. All right, again, insurance is extremely important. Errors and omissions, it's great, but you want to make sure what it covers because it doesn't cover everything. So one thing that I do for a lot of my realtor clients and friends is we stop operating individually and people start operating under a company, right? So that is very important. I advise that for everybody to do because now you are separating the liability. You're separating your assets that you have as a person from the assets that your company have that may be subject to a lawsuit. For example, in Florida, the laws changed in January 2015, and a single member LLC does not offer the same liability protection as a multi-member LLC offers. That is why I don't like to form single member LLCs in Florida for any business. Besides that, in Florida, as a realtor, you're able to have your license under a professional association, right? You don't have to operate under your own name. You can do it under a professional association or an LLC. But one of the requirements is that you be the only owner. So because I just told you the law changed in 2015 and single member LLCs don't offer the same liability protection, I don't like to open single member LLCs for realtors. Instead, I like to open professional corporations or professional associations, is the same thing, PAs. And that way you're going to get a couple of, well, you're going to get protection from liability, such as you're going to be a separate legal entity from the owners. So you are not subjecting your personal assets anymore, is whatever the PA has. And the PA is really not going to have anything. You're going to, if you file for S Corp status, you're going to have pass-through taxation. So you're only really paying tax once. You will need to do corporate formalities. You know, you have to renew every year. You need to have the corporate minutes, and we can assist you with all of that. So why would you want to form a PA if I just told you to obtain insurance? Well, you want to have that because your insurance may not cover you against fraud, breach of duty, breach of contract, negligence, bodily injury, misrepresentation regarding the condition of the property, Consumer Protection Act, earnest or escrow money dispute, misrepresentation regarding flooding or leaks, misrepresentations regarding the value. You might not be covered against all these things, but if you're separating the liability from you as a person to your entity, then now they can go into your entity, and your entity is not going to have anything because what's going to happen is your broker is going to pay the commissions to the entity. The entity is going to give you that money to your personal account, either as salary or as distributions. So there's really nothing in the bank account that could be subject to a potential lawsuit. And now, because you're doing this, right, you're going to have this corporate bail, which is like a protection that you're going to have. So if somebody tries to sue you, they have to sue your entity, not you personally. So your license, we have a little package for realtors. What we do is basically we will form the company, we'll obtain the tax ID, we'll help you fill out the form so you can do the S Corp status, so that way you don't pay tax twice. You will need to give yourself a salary, and you can discuss all of that with the CPA. We'll help you fill out the form for DBPR, so that way the license is not going to be in your name anymore, it's going to be in the name of your PA. We'll prepare all the corporate documents and all of that. That's usually what it would cost, but we do have a package for realtors. This gives you liability protection because now you're no longer operating under your own name, you're operating under your PA, which I think is what everybody should do. Let me see, there you have my contact information. I think I have a question. Pregunta, ¿cuál debería ser el ingreso mínimo para crear el PA? Yo diría que desde el comienzo, para protegerte contra liability, deberías crear un PA. Porque ¿por qué trabajar bajo tu propio nombre y exponerte? Mejor es que trabajas bajo una entidad y cualquier problema que haya solo demandan esa entidad y esa entidad no va a tener nada. En cambio, si te demandan a ti, pueden atacar tus otros bienes. Okay, well, that's my contact information. You can reach out to me via phone, via WhatsApp. That's my website, Instagram. I'm very active there too. So let me see. Let me stop sharing. I don't know if anybody has any questions.
I have a question, Gisela. If a contract, you know, have we marked on 19 a condo, or let's say the lead paint disclosure, and we also mark condo disclosure. If the seller or the listing agent only returns back the contract without the other documents, is the effective date starts when we have the entire contract together, meaning all the other documents?
So if the contract says that it includes all those documents,
Correct.
right? But it wasn't a contract, it was an offer. So you sent an offer asking for all these things, and then the seller returns only this,
Only the contract and hasn't,
then I would say that's a counteroffer. Because you required all these things and the seller's not giving you all those things, so it's a counteroffer.
okay. No, we had a situation with another realtor who I was assisting with, and they were late in returning, but then they wanted the effective date to be the effective date of the signing of the contract. And they returned all the other documents, let's say 3 days after. So that's why I wanted to know which is the true effective date. Once we have all the documents, or the effective date is the signed date of the
You
contract?
can make arguments either way, but I would argue that it's not an effective contract because you've required all these things and they've only given you this, so it's a counteroffer.
Okay, all right. Thank you.
No problem.
With another question, with the financial contingency, so it's important to know, it is our responsibility. I know we always create the critical date sheets or transaction date sheet. So it's not the responsibility of the loan officer to remind their client of the financial contingency.
At the end of the day, it's the responsibility of the buyer to know when their financial contingency expires, right? They are the ones that are buying, they're the ones that are getting the loan, it's their responsibility. I have seen it time and time again where loan officers don't even know when that expires, they don't even care.
Right.
I have seen it where agents, they know when it expires, but then they're up to the wall because they cannot extend it. The seller doesn't want to, the loan officer is not moving fast enough. So I'm not saying it's 100% your responsibility, but the buyer will make it yours. So you want to put it in writing. You want to say, this is when the financial contingency ends. If the seller doesn't want to extend it, then it's your choice, buyer, to either cancel the contract or to buy it not subject to finance and understand that you're putting your deposit on the line. And I would put all that in writing. Any questions, please talk to your lawyer or please talk to whoever's representing that transaction. Because what you want is for them not to come after you and say, why didn't you tell me? I told you, and I asked you to make that decision.
Correct. I love how you said to all of us that everything's in writing, because nowadays we're in the age that everybody likes to text.
Yeah,
Even
put it
though-
in writing. Look, you know what I do a
I
lot?
put
It's
everything
called
in writing,
CYA.
like, even if
Because
my
people don't like to sign whatever, but you can just send an email, pursuant to a conversation, we discussed the following A, B, C, and D, and you acknowledge this. Please
Very
let me know
important.
if you thought of it differently. Boom, they're never gonna respond. I don't care. You save the PDF, that email is PDF in your file that you informed them. You CYA, you CYA, you CYA. Because when they come and say, no, you never told me, you did. And you want to send that thing where they tell you that they read it, the require receipt, all of that. Save all of that.
It looks like there's another question there. I guess if they work under LLC, que si lo deberían de cambiar a una PSA.
Mi consejo a todos los clientes que tienen LLC, que solo tienen un miembro, es que no se manejen de esa manera porque la ley cambió en la Florida en enero del 2015. ¿Ok? Hubo un caso que se llama Olmsted y de ahí cambiaron todas las, ¿cómo se dice? Los estatutos. Ahora, bajo la ley de Florida, un realtor puede operar bajo una LLC, pero solo puede tener un dueño, el realtor. Entonces, por eso es que yo prefiero crear PAs, Professional Associations, que son corporaciones profesionales, porque así solo tiene un dueño, pero tiene la protección, liability protection que tenía antes la LLC o que tienen las LLCs con más de un dueño. Esa es mi recomendación.
Thank you. Now, you mentioned something about errors and omission. So if we're doing errors and omission, and I guess we would have to go back and read the policy. So the extension of it's like the extension the extension of what the coverages are. But you think that having errors and omissions is going to protect you against these lawsuits. But if it really isn't, then where's the protection?
I don't think so. I don't think it's going to protect you against anything. This is what I think, okay? I think errors and omissions is good for certain things. Like this was missed, especially for like notaries, this was missed or this wasn't. But you really have to read the policy because every policy is different. We want to call it liability policy. We want to call it errors and omissions, but what is it protecting against? And that's the main thing. When people come to me and they told me, Romy, they sued my brokerage. Romy, they sue me as a realtor. What do I do? The first thing I do is let me see what insurance you have. And then when we look at it, we see all these exclusions. And I'm like, well, let's try it anyway. Let me send them a letter. Let me tell them to cover you. Meanwhile, the lawsuit starts ticking because you only have 20 days. So I say, let me make an appearance. Let me ask for more time. And let's see if the insurance wants to cover you. Sometimes the insurance says, no, we're not going to cover you. Sometimes they say, we're going to cover you, but later we may decide not to. And sometimes when I do think in my heart of hearts that insurance should cover you because I'm looking at the policy, I'm looking at the cause of action, then we'll sue the insurance to cover you. And we'll still defend, but we'll sue them to cover you. So it's, you know, I don't want to say it doesn't cover anything. I don't want to say it covers everything. It really does depend on the policy. And then even when you have the policy, the insurance job is not to cover you. So sometimes we do have to do certain actions to cover you. You know, and there's certain things that we can do depending on what you're being sued for. Now, just like I'm always an attorney, right? Even if I'm chilling in the park with my kids, I'm still a lawyer. You guys are always realtors. And one thing I forgot to mention is a lot of realtors are now like, you know, thinking that they're YouTube personalities, and that's all great, but they're offering things outside of their, let me look for a property in the MLS. They're offering like fix and flips. They're offering, you know, let's help you in the auction. All that is great, but understand that you're still acting as a realtor and they're going to hold you to a higher standard, and your brokerage is going to be responsible and you're going to be responsible if any of that goes sour because the client got a bad deal, which I have seen it actually. We had a lawsuit where an agent was helping somebody buy foreclosure auction. The person bought the foreclosure auction, they got it. Of course, there was no title search. So then they had a bunch of issues. And then now they were suing the realtor and the brokerage, even though the realtor didn't act as a realtor, they're still a realtor. So if you're doing things outside of your real estate arena, outside of working with your brokerage, make sure that you make people sign releases. And if you're a broker, your agents, you're responsible for your agents, right? So the principal is responsible for the agents. So you want to make sure that you educate them and tell them if you're doing this and that outside, you need to have releases, have them sign a release for you too, an indemnification agreement, because whenever a realtor misbehaves, does something bad, it's going to come after the broker too. And the insurance policy won't cover you because the insurance policy will say they're acting outside of the realtor profession. That's what they will say, because I have seen it. I had a case right now. And the people that are suing were saying, no, we're going to hold you to a higher standard because you were acting as a realtor. So that will go forward and this exclusion will go forward. So now the broker and the realtor both have to hire their attorneys to defend.
Thank you.
No problem.
I guess if you can share your information again, that way we can always keep you handy.
Sure. So the phone number of the office, and we have WhatsApp with that too, is 305-921-0976. I'm also very active on Instagram, and you guys can reach out me directly. And my Instagram handle, it's my name and my last name, which is Romy, R-O-M-Y, and my last name is Jurado, J-U-R-A-D-O. And we do, you know, our office is fully bilingual. I do see a lot of these cases and everything in between. So if there's anytime a situation you're not sure, we do like to serve as, you know, like an extra hand to the realtors to help them navigate these difficult waters that we are now facing with everything that's going on.
Thank you so much. Does anybody else have any more questions? Romy, are you able to share your PowerPoint with us so that I can
Sure.
share it with all the brokers?
Yes, let me know what email to send it and I'll send a PowerPoint.
The Gisela, the one that I was writing to.
Okay, no problem. Sorry if I spoke a little fast. I do get excited. I really like this area of law. So I tend to just give it.
It's okay. We'll just invite you again. Next time you can do it in Spanish or a little slower, you know.
Yes.
Just keep inviting you. I'm like, wait, can you understand? Can you repeat that part again?
No worries.
¿Alguien tiene alguna otra pregunta?
Yo. Romy, hi, honey. I'm in
Hi,
Colombia.
Lily.
Honey, one question regarding the contract with developers. You know, I have a lot of clients who they signed purchases in many condominiums, and the closing date is delayed more than a year, and they have lost obviously all the rates that they have negotiated already with the banks, and
Especially
now they want to see if they have some kind of possibility to sue the developers.
Okay, so at one point we were doing a lot of pre-construction. Now has decreased a little, but at one point we were doing a lot of pre-constructions, and clients would hire us to review the 100-page document and basically explain to them, and a lot of them foreigners, in Spanish what they were signing up, for, because there's no such thing as a form contract. And I remember that in a couple of them, we actually negotiated that because the developer in their agreement said, oh, we could extend, we don't know when we're going to open, blah, blah, blah. And I remember adding clauses that said that if they extended over this period of time, and I remember it was 3 months, 6 months, then they would be a special type of agreement with the client to receive a discount or something like that, because their contracts don't say it, right? So had they negotiated this from the beginning, yes, they could do something. Right now, we would have to take a look at the contract to see what it really says and see if we can make some type of argument of basically all the money that they're losing because of the interest rates have spiked and all of that. So we would really have to take a look at each contract to see what we could sue for.
Okay. Yeah, because the thing is, the developer just keep making promises and promises of the closing. And this one, I have a couple that they bought a penthouse in Sunny Isles, and they have been waiting for the closing for more than 2 years, and they have lost a lot of money. So I'll write an email to you with this.
Yeah, we need to look at it and see if we can make some type of argument. Where is the couple from?
London.
Okay. Yeah, we would need to look at the contract and then see if we can basically, I would start with a demand letter, right? And then from there, if I do think we have a good case, file a lawsuit.
Okay, great. Thank you. You look so beautiful, by the way.
You always look beautiful, but I can't see you.
No, you can't. I'm in Colombia now. On the street is a little bit not secure.
Oh, okay. No, be careful, please. Any other questions?
I think you covered it. Thank you so much.
You're
And like I said,
welcome.
I'm sure we'll invite you. Romy, with the club, we do a lot of events and seminars and things. So we're always looking for key speakers. So I'm sure we're gonna have you again.
Fantastic. Well, it was
If
very
you
nice.
if you accept our invite, of course.
Yes, I will. Absolutely. One day let's do a live event. I miss live events.
Yes, that would be amazing. Thank you.
I'm sorry, honey. One last question, and I'm going to do it in Spanish because that involves a lot of people. Nos están diciendo de que pronto, pues hay todos los internacionales que compraron propiedades necesitan reportarlas si es agricultural o si es residencial, tienen que reportarlas, o si no van a tener que pagar $1,000 diarios.
Los venezolanos y los cubanos, los de Siria, los de North Korea, sí, esas personas sí.
Pero me dicen que eso envuelve a cualquier internacional que haya comprado con una LLC y que si no lo reporta a partir del próximo año van a tener que pagar $1,000 diarios de multa.
¿Estamos hablando de la ley de la Florida o estamos hablando de otra cosa? Porque la ley de la Florida, claro que ahorita está todo en el aire, ¿no? Y nadie sabe, todavía no hay los documentos de registro, pero la ley de Florida solamente envuelve a los venezolanos, los cubanos, la gente de North Korea, Siria, y no me acuerdo, Rusia, los otros países, China, pero no son todos los extranjeros, solamente ese público delineado. Es la ley que salió ahorita julio 1.
Ok, perfecto. Listo. Entonces, muchas gracias.
Un placer. Bueno, cuídense todos. Bye bye. Have a nice rest of the week.
Thank you. Chao.
Bye.
Chao.
Gracias, Rocío. Hasta luego.
Bye. Thank you.
Excellent.